Section 3. Foreclosure. When property owners find themselves unable to make their mortgage payments, they will often hire a realtor to list the property for sale. An excited realtor may take the listing without obtaining the pertinent mortgage information, only to find out later that there's not enough equity in the home to pay the commission or clear the title. It is always advisable when listing property to verify all mortgage information. Asking the owner to sign a release of mortgage information from the lending institution is wise. This will allow the realtor to verify that there is equity in the property to pay out the existing encumbrances, mortgages, back taxes, and real estate commission. Taking a listing without checking these details leaves the realtor wide open for problems. It is important for the realtor to recognize that when a property that may be subject to foreclosure proceedings is listed, the listing may be voided by a court-ordered sale at any time. The legal definition of foreclosure: a legal action taken by a mortgagee to obtain possession of a property by reason of the mortgagor's default in payment of the principal and or interest in the mortgage debt. Obtaining a title search on the listing will show if there is any pending litigation or foreclosure action in progress. A clear title is a good indicator that there will be enough remaining equity at the time of conveyance to transfer the title. Occasionally, a buyer may be left out on the street on possession day because the owner was unable to clear the title and the property title was unable to be transferred. Sometimes the property can be tied up for days, even weeks, while the lawyer sorts out how to clear the title, who gets paid, and how. In this situation, it is possible that the realtor may not get paid at all. If the owners come right out and tell you that there is not enough equity in the property to cover the commissions, then it is important to have them deposit the amount of the commissions into your brokerage trust account to ensure that the commissions will be covered. If they refuse to do that, then it makes sense to walk away from the listing, as you likely will not be paid for all your hard work. Although there is nothing to prevent owners from listing their property during the first part of a foreclosure, it must be remembered that the court is not bound by their agreement and can give conduct of sale to any party and may enter into a new listing agreement. This means that somewhere during the life of your listing, the board will automatically be canceling it. Foreclosure proceedings. When a borrower defaults in making the mortgage payments under the mortgage contract, the lender can take action to protect the lender's security. The most common remedy used by lenders is called foreclosure. The focus of the foreclosure proceeding is to liquidate or cash out the security that was given for the mortgage loan. Court action to obtain title to the property is taken unless there are higher priority encumbrances on the land. One late payment does not necessarily mean losing it all or even the start of a foreclosure procedure. Financial institutions do not want to begin a costly foreclosure action, as it is an expensive and time-consuming process that they would like to avoid if at all possible. When borrowers are in trouble, banks have techniques in place to save a loan. They would rather use their save a loan procedures to help resolve this financial predicament. For example, they may work out a reduced payment schedule that the borrowers can live with as temporary relief. The steps of the foreclosure process. To trigger a foreclosure process, first there must be default under the terms of the mortgage. This is usually a failure to make the mortgage payments, but it can also be a default in payment of taxes, strata fees, or other terms that have been described in the mortgage agreement. Steps in a foreclosure proceeding. Demand letter. The letter accelerating the loan and giving the borrower short period of time to pay out the mortgage or else face foreclosure. Petition, filed in BC Supreme Court Registry. The lender is the petitioner, while the borrower and all other charge holders whose interests rank in priority behind the lender are respondents. Order nisi, the first order in the court. It establishes, amongst other things, the amount required to redeem the mortgage and the time period given to the borrower to redeem. Now these are one on the left side, one on the right side. These arrows. Left side, it says judicial sale. The petitioner may choose to have the property listed for sale by the court. Unless special circumstances exist, the petitioner only seeks this order at the expiry of the redemption period order made after application. The court approves the sale of the property if the sale proceeds do not pay the petitioner in full. The petitioner will seek the deficiency from the respondent borrower under a court action. On the right side, it says order absolute of foreclosure. If the redemption period has expired and if the property is worth the same amount as the mortgage debt or more, the respondent borrower is judgment proof, i.e. has no assets or money to apply towards the deficiency, or there are no offers under a judicial sale. The petitioner can seek an order absolute of foreclosure, which results in the petitioner becoming the new registered owner and all respondents being wiped off title. No further action can be taken against the respondent borrower after the order absolute has been granted by the court. So number one, let's do it again, demand letter. The first step in the foreclosure process is a demand letter sent by the lender. A demand is made on all of the people who are named in the mortgage, the current owners, the guarantor, and sometimes even previous mortgagees. The demand letter will include the name of the borrowers, the identity of the security, confirmation that the lawyers are acting for the lender, the reason for the letter, and the actual demand for payment of either the arrears or acceleration or a combination of both. The letter will give a specific time in which to come up with the arrears. It will also explain the consequences of non-payment. This letter will be sent by either registered or certified mail. If the demand asks for acceleration of the mortgage balance, it means that all monies are due and payable immediately. A time deadline is given for payment of the mortgage balance, with the consequence being that foreclosure proceedings will start after the demand period expires. Once the mortgage is accelerated, the lender cannot charge a prepayment penalty. 2. Petition. To start a foreclosure action, a formal application is made in writing to the court requesting judicial action. This declaration of facts, called a petition, is sworn before an officer of the court and then issued and filed in the court registry in the Supreme Court of British Columbia. In this document, the lender is called the petitioner and the homeowners are called respondents. All parties who have an interest in the property, such as any subsequent mortgage holders or people with registered judgments, will rank behind the lender. All parties will receive a copy of the petition. Parties to the petition. A copy, this is A, parties to the petition. A copy of the petition gets served on any person whose interests are affected. Examples of people who would be served, would be the borrowers, any guarantors, the registered owners of the property, tenants, and any other mortgage or insurance holders. B. Remedies requested in the petition. An accounting of all monies owed, foreclosure of all the respondents' interest in the land, a personal judgment for the amount owing against all parties liable for the debt, an appointment of a receiver if there are rents involved, possession of the property, a certificate of pending litigation, and request for court costs. Included in the petition is a request for an order for sale, so that the court may order the sale of the mortgaged property. Upon receipt of this order, the property is usually listed, although most often the lender will seek an order for sale by a separate notice of motion. 3. Affidavits. An affidavit is a sworn written declaration made before the court outlining the facts in the petition. In a foreclosure proceeding, it sets out the particulars of the default under the mortgage, and there may be several affidavits in support of the petition. These are often submitted as the process progresses, the first affidavits being registered in the court at the same time as the petition. The affidavit is served on all respondents. For appearance, if the owners of the property or the people being foreclosed cannot afford to redeem the mortgage, they should file an appearance at the courthouse. An appearance is a court document by which individuals indicate they will defend or otherwise participate in legal proceedings against them, or in which they have an interest, which might be affected by such proceedings. They should mail or deliver a copy of the appearance to the lawyer handling the foreclosure. The lawyer must serve copies of all of the court proceedings to the other party. An appearance is a simple form that can be completed without the help of a lawyer. There is no fee or cost to file an appearance in the court. If there is equity in the property, then the owner should hire a lawyer to help protect that equity. 5. Notice of hearing of petition. This sets out the details of the hearing. It will specify the court date, the time, and the location of the hearing. 6. Order nisi. After the petition and the affidavits have been served on the respondents, the petitioner lender can apply in the Supreme Court chambers for an order nisi. This is a court's device that will become absolute unless the adversely affected party shows the court within a specified time why it should be set aside. A. The order nisi asks for judgment against the borrower, legal costs, conduct of sale. States that the homeowners may redeem the mortgage by paying into the court the amount found to be owing. Provides the method of paying the amount owing under the mortgage, and specifies a time and date that the monies must be paid by. 7. Certificate of pending litigation, referred to as an LP, formerly called a lis pendens. The certificate of pending litigation is filed in both the court registry and in the land title office. This registration means that there is pending litigation, a lawsuit against the property. Its purpose is to prevent any dealings of the property until the foreclosure action has been completed and is registered at the same time as the petition and the affidavit. 8. Redemption period. If a house is owner occupied, and depending on the equity of the property and its condition, the redemption period can usually be 1 day and 6 months from the date the court pronounces an order nisi. This time may be altered, reduced, or extended depending on each individual situation. These times can be varied if it is proven that further damages will arise if the property is left as it is for 6 months. At the end of the redemption period, the mortgagor can apply to extend the redemption period if they can update the mortgage, pay the owners immediately, and if they can show that they make the regular monthly payments after. If there is a probability that the person may redeem the mortgage, the redemption period can be further extended. An appointment of a receiver may be granted upon request of the lender if the property is rented. The receiver will collect the rent and manage the property. The amount that the receiver is paid for his services will be added to the amount payable to redeem the mortgage. 9. Order for conduct of sale. Once a property is subject to foreclosure proceedings, anyone who may be potentially affected by the foreclosure action may apply to court for an order for conduct of sale. This allows the court to instruct that the property be listed for sale, and it prevents anyone else from listing the property, even the owners. If you are involved as the realtor and the property is being sold under court order, it is best to obtain a copy of the order to see if any conditions for the sale are set out. It will spell out whether it provides for a payment of a real estate commission and how much. If you already have the property listed, the court order may void your existing listing and the lender may list the property with a different realtor. 10. Order made after application, order approving sale. An order that approves the sale of the property. 11. Order absolute. If the court has not granted an extended period of time and if payment has not been made within the specified redemption period, the lender then goes back to the court to apply for an order absolute. This is simply a ripened decree nisi. The order absolute is a court decree that has become unconditional because the time specified within the decree nisi has passed. The rule is absolute and it bars the interest of all the respondents in the property, orders that the lenders have possession of the property, and extinguishes the judgment. Upon obtaining the order absolute, the lender can make application to the Land Title Office for a certificate of title. This will allow the lender to deal with the property as the registered owner and keep any profit upon the sale of the property. And that's the end of this section.